Welcome this morning to our workshop, QWR Letters, Qualified Written Requests. And I'm going to have a guest on with us today who can answer all of our questions. But before we start, I'd really like to share with you the legal disclaimer. I want to say again at the beginning of every one of these workshops that I'm CJ Holmes, founder of Homeowners for Justice. I am a licensed real estate broker, but I am not an attorney, a CPA, a loan modification expert, or a securitization auditor expert. I don't provide legal, tax, loan mod, or securitization advice, and I cannot guarantee the effectiveness of anything that we talk about on the website or my website or this video. I don't represent these folks. The fact is, what I've done is tried to figure out from the perspective of owners, what can they do to save their homes from foreclosure and keep them and perhaps get some leverage in trying to get better loan modifications, postpone the auctions, whatever it is that the owners are really trying to do with their homes when they face this situation. And so please don't think that I can be held liable for any loss or damage of whatever nature, because I don't know what your situation is. I don't know what your resources are, and I don't even know how long some of these things we talk about are going to take effect, because it's really obvious that we're hitting some resistance. And I've been being told, emails, conversations, that the banks are fighting back and as best they can, like changing laws and things like that. So to me, it's a race to exposure. We must get as many owners on board doing this, understanding their rights, and doing these, what I call relatively simple things, legal recourse that they have against the banks. And so today, the qualified written request is specifically one of those things. It's a letter, you can send it, you don't have to have an attorney, and hopefully today with our discussion, you'll really be able to understand why we say qualified written requests are really the backbone of owner defense. So I want to also point out that the content on the website can change without notice. We're constantly updating, constantly trying to improve what is going on and how we would present the information. So today, there's the qualified written requests. I'm going to show you where on my website you can find that. It is based, the requests we're going to discuss refer to two federal laws. So I've already had a question from someone in Washington State. Does this apply to everybody, or is it just California? And I've immediately changed the website to say, these are federal laws. This is the nation. This is you, your neighbor, anyone, anywhere in the country. So please spread the word. We're going to be talking about RESPA and the FDCPA, the Fair Debt Collection Practices Act, and the Real Estate Settlement Procedures Act. So today, as we start talking about the process, I want to just show you real simply what it is, step 1, 2, 3. And then we're going to invite Linda on the show, and we're going to start asking her questions so that she can answer them. Four steps. You submit the letter, and always send it certified, signed receipt requested. Remember, you are sending these to the bank servicers. So you want to make sure they get it, and you want to see who signed for it. Always keep a detailed log. Re-request any missing information or demand clarification. So step 3 is going to be based on more or less what you get or what you don't get. If you don't get any response whatsoever, send the letter again as a second response. And then step 4 falls into our coordinated strategy. We're going to include this and the bank's responses to it in the owner statement of suspicious documents. But that's going to be a lesson for another time. It is down on the Homeowner for Justice webpage. So here, let me show you first where we're looking at on my website. We're on the foreclosure defense. It's the very first page, the foreclosure defense, and it starts with 11 foreclosure defense considerations. Qualified written requests are number 2. So I'm scrolling down to show you on the screen here's the qualified written request paragraph. I don't have a separate page for it. This is where we're discussing. You'll notice that there's a couple of links. I've tried to highlight all the links in bright blue so you can find them easily and see that they are links. We have a sample letter in a Word document format. If for some reason your computer won't print, pull it up, then go to the PDF format and you can just retype it. We've also got a couple of links to what the timelines are right now. That's changed in January. Linda's going to bring that to our attention. Also a link to the Consumer Financial Protection Board. I've been told that they're the ones that enforce the RESPA issues, and there's also a couple of articles. So, without further ado, Linda Zimmerman is joining us. She's a certified forensic loan auditor. She's where I go to get my questions answered. So, Linda, welcome to the show.
Thank you. Good morning.
Good morning. And I've been asking you over the years, it feels like years, about qualified written requests. So what would you say to an owner who's hearing this for the first time? What is this and why should they bother?
It's a provision that's made available to us through RESPA, which is federal laws concerning the practices in real estate, in mortgages. And it's your right to question the servicer anything about the servicing of your loan. And it has to be done in writing. There was a time limit previously for them to respond to acknowledge within 20 days and then respond within 60 days. But those timelines have been greatly shortened, and that's to expedite things, and we're glad, they're re-emphasizing the importance of this RESPA regulation.
And why is it so important, in your opinion?
Because, for instance, here in Florida, when I've been in court, and even in other states, just listening to the judge, I have without fail, no matter if the judge has been a little bit sympathetic or completely against the homeowner, the question was always, did you write a qualified written request? And so it should be done no matter where you are in the process, and it can be done even if you aren't in default, if you just want to know these specifics about your mortgage.
And so what kind of, we're going to go over those specifics. I've got the sample letter that you and I have discussed, and we're going to go over that. What I'm showing on the screen right now is the link to the Dodd-Frank Act, where they've shortened the timelines, so everyone's welcome to read that themselves. Let's move into...
Remember, this is a 600-plus page document, so this is a shortened version that applies to the rest of the till.
Okay, shortened version that maybe we can get our heads around.
Yes, yes.
Okay, so here is the example now on the screen of the Word document that's on the website. If you want, you can pause this, you can open up that document, and then you can actually go down the list and understand what we're talking about. And again, I want to add that this may change. Oh yes, and I wanted to point out that when you're on our website, hofj.org, and you're looking for this link where it says sample QWR, when you open that up, it's going to have a different title if it's been updated, because I've started to put this last date that we did this on the title of the document. So it's going to be called something like sample QWR 02-2613. And if that date differs from the one that you've already got, then it'll be an updated version. I'm just passing that on. So back to the document. This is the idea is that you would edit, each owner would edit this. They put in their name and property address, the date. They would put in their servicer, and then this QWR. Here's a question. What if their servicer is something like Ceteris, not a mega bank? Should they still do this to Ceteris?
Well, that's what you have to check on your last statement. Usually on the flip side, they'll have a customer service mailing contact address and a specific address for the QWR. If it's not there, be sure and call the servicer and find, notate who you spoke to and find out what that mailing address is, because if it doesn't get to the proper place, it goes in a black hole and you will lose your rights.
Okay, so and I'm taking notes because this is the first time I've heard of this, and I'm so glad you're doing this with us. Thank you so much, Linda. So every owner should take their statement, turn over the statement, and look for the specific mailing address for mailing qualified written requests.
Yes, it'll usually be in dark letters of qualified written requests, because these laws have tightened up and they know they have the accountability. But if it's not there, be sure and call again. Make sure you notate who you spoke to get the address, and then that will be the address that you use. Don't just use customer service.
Okay, so there we go back to log everything. Keep a good written log. Log who you spoke to. Okay, so now assuming that we've found the correct spot to, the owner has found the correct spot to mail the qualified written request, do they just mail it there, or should they copy, you know, their foreclosure trustee? Should they copy anybody else? What do you say?
The only one that needs to receive this for action on it is the servicer. However, you want to build up and let them know that you're putting the other parties involved on notice that you have done this. Not that they're going to answer it. It's addressed to the servicer. However, you want to CC all the entities that you know that are involved.
Okay, so which entities would those be?
Well, for instance, if you had Ceteris and they're just a sub-servicer, and you want to, if you would have to write to either Ceteris or the master servicer, then you want copies to both. You want to make a copy to the trustee. Any and all agencies that are named on your foreclosure documents.
Oh, golly. Okay, so that means the owner now is, going to go look at the workshop on analyzing our recorded documents so that they can understand how to read those and identify where else they should be sending this. So,
correct.
All right, and
they may get back letters from these uninterested parties that, we're not the one you send it to. Well, you're just copying them on it, so don't worry about it. Just keep it in your file.
Got it. Okay. And so don't expect any answers from them either, basically.
Right.
Okay.
Right. The only one that's required under federal laws to answer your questions is your servicer. Not the trust, not the originator, no one but the servicer.
All right, and so moving down the letter, it's pretty obvious at the beginning how to fill that in. The first paragraphs we've written to reference both of these federal acts, RESPA and the FDCPA, and then another paragraph about, hey, I just need peace of mind. It seems to be getting, you catch more flies with honey than vinegar. Now, I want to talk about the items that are requested in the letter. So the first several items start talking about or requesting specific information about the loan payments, the amount of principal paid up to the date of the letter, the amount that it would take to pay off the loan, the monthly principal and interest, and escrow payments, when they were paid, and the date of the loan's closing to the date of this letter, a complete payment history, including how the payments were applied. And I want to make a little comment here, which I'm sure, Linda, you have found. Many people have told me when they get information back from the banks about this, it doesn't match their records.
Correct. The importance of this.
And in fact, I think we had one contact, I think it might have been Lorraine, and that had different responses back from two different requests. So she requested the same information from the same entity and got two different answers. I'm not surprised. Just
no, and this will solidify. If you go to court, this solidifies your legal case. Which one's right, Your Honor.
Exactly. Exactly. How can I know what's right when they're telling me two different things?
Anyone who's gone into modification can find out this way if their payments have been indeed credited to their account,
right,
or have been kept in a suspension account that the bank is just holding and gobbling up and not crediting.
Exactly. Now, one of the things that I've been recommending, because people have been sharing with me, asking me for some, my opinion on should I take this loan modification, and I've been saying First off, have you ever gotten, you know, a response on your payments? And there's dead silence on the phone. It's like, and I believe it's because most owners believe they just have been, if you will, brainwashed into thinking that the servicers are always keeping accurate track. And what we're finding out is not only are they not keeping accurate track, they are intentionally not keeping accurate track. They're putting, like Linda mentioned, tell me what a suspension account. They're putting the payments in the suspension account. So what is that?
A suspension account is specific for a specific purpose to be accredited, and according to federal law, on 30 days. At the end of 30 days, they either have to apply the money to your account to where it's intended. In other words, they're deciding what to do with it. It's in suspense. However, on the 30th day, it has to either be refunded or applied to your account. And I truthfully have never seen anywhere they've applied it to the, no, I take that back, one where they've applied it to the account.
Oh my goodness, they applied it correctly once.
That was about the only right thing they did in the whole procedure.
And see, this is the problem, and this is why I want the owners to wake up. And this doesn't matter who you are, which part, if you're making your payments or not, if you're facing foreclosure or not, it's immaterial. Right now, the servicers have discovered they can make so much money by not applying your payments to your account. And then, of course, you're in arrears. And so then the fees multiply. And then foreclosure starts, and the owner goes, what? I'm in foreclosure. I've been making my payments. What is this about? Or I've paid the loan off completely and I've lost the house to foreclosure. This is a real nasty syndrome that will only continue to get worse unless the owners stop it. We have to do this ourselves. So back to these items, I'm on number 6, the payment dates, the purposes of the payment, the recipient of any and all fees and costs that have been charged to my account. And I just want to make a comment here of what I've seen. Linda, you can share anything else you've seen. And that is, people have sent me their statements. And I have seen on these statements, once they've stopped making payments, they still get the statements. And the servicer is tacking on all of these kinds of fees, like a broker price opinion, like a document analysis, or they look at documents or something. They make these I swear, they make this stuff up just to pad the amount of money they get when they foreclose. Is that right, Linda?
Absolutely, because they charge back to the trust.
Right.
And the trust then takes that money out of the general pool from the particular trust, and the servicers, you know, they're gravy. They get easy money. Another thing that was addressed in the Dodd-Frank Act was that I personally know a friend of mine who requested this information, and she said that her principal wasn't coming down like she had supposed it should. And when she looked at it, she was getting a late charge of over $80 on a payment that was maybe $600 a month, and she couldn't figure out why. And we had a contact with Paul, his wife worked with Bank of America, and she told us, oh, that's because the servicer did not pay their state taxes in time, so they back-charged every one of the clients that they didn't pay the taxes on.
Oh my good! And so they got rewarded for failing to perform.
Their state payment was paid by the homeowners.
Right. And see, this is the problem with this whole machination, and that is, whenever the servicer makes a mistake, they make money. So they have a perverse incentive to make as many mistakes as possible, or intentionally, because it ramps up their profits. Oh my goodness, this is why it is so important that we stop them. And everybody needs to file a qualified written request. So now I'm looking at number 7. We're requesting this letter that you can just use for yourself as owners. Put in your own name and loan number, figure out the correct address to send it to. All the requests are the same. They don't have to change these requests, right?
Correct.
So number 7, you as the owner with this letter are going to be asking for a copy of all the documents executed by me, the owner, at the closing of my mortgage, the name and contact information of the current holder of the mortgage I signed. So expand on that, Linda.
Well, we really, the foreclosure as the owners and holders of the note.
Right.
And you'll see on some documents that we're either the beneficiary, the signer, or the blank. That's like saying I'm either the mother, the father, or the friend. It's so ambiguous. We have the right, according also to the reinforcement of the Dodd-Frank Act, to within 10 days know who the true owner of our note is. Now, if you know that they're just the servicers and they're putting themselves down as the owner, now you've got them for lying, and it's going to be brought upon the court later on. If not, if they do identify the true investor who is, purchased this for the benefit of many, many people who are certificate holders, it's giving you a basis of knowledge. We're either going to get a lie or you're going to truthfully find out who owns and holds your note. And they have to tell you this. They can't sidestep it. 10 days.
Okay, now, here's the point, and that is they won't, or they'll tell you something else. And that does happen, right?
Right. They respond saying it's private information, it's insider trading. Well, right there, if they use insider trading, we know it's securitized.
Right.
Blowing the whistle on themselves there. There's common things that they will answer to sidestep, just giving a response in time, so they don't come up for federal damages.
Right.
So
right.
You and I were discussing previous to this is make a list of the objections and then a list of the answers that the homeowner can then do to answer back to them.
Right. So moving into the rest of the questions, and this is why these questions are so important, because like Linda said, they often, and when you look at the analyzing your recorded documents, you will discover that this is why I call them fake. One of the reasons is that they've made up these titles. I am the mother, the father, or the brother, the sister, the cousin, the aunt, or the uncle. I mean, literally, an agent for this, as attorney in fact for that, and that's all in the same title. It becomes almost laughable, and it would be laughable if people weren't losing their homes over it. And so I'm looking now at number 10, the date that the current holder. So we've been requesting them to say, tell the owner who holds the note, who is that owner, and when did they acquire it? What is the date that holder acquired my mortgage and from whom? Now, Linda, here's a question to you. If the servicer had done it correctly, what should be the answer on that? Let's say the loan was securitized. Let's just say it's Bank of America. It was countrywide, Bank of America. So what do you think they should actually respond?
Well, the countrywide would probably be, 2005, 2006?
Right.
At the latest, 2007?
Right.
So that's when they were, in countrywide, did seawalls and CHLs. They did massive securitization. So and part of that PSA agreement says that all these documents, the assignments, were to have been executed at the time that it became a part of the trust. And then when they needed those documents for foreclosure, bankruptcy, or whatever, they could be recorded at this time, at the present time. But the execution date had to be back there at, say, 2006. If your loan was in 2006, it should be in 2006, within a few days or a few months of your closing on your home. Now, it also tells us that the people who are signing these documents today as presidents and vice presidents of this company, that's another reason it can't be legitimate signatures, because those assignments were supposed to have been executed and signed, and some of the attached filings in the PSA give the actual names of the people who would be appearing on those assignments, and they're certainly not any of the people that we're seeing today.
Right. And that does, from your description, it makes it sound as if it would be pretty difficult, if not impossible, to actually fake that now.
Absolutely. It
Yes.
takes more work than they're willing to go through. I spoke to a Charles Wilshin, the attorney in New York, who is really fighting from a new angle of contracts. And I asked him, because he worked in securities, when did you discover that this was all fraudulent and it wasn't going to work? He said it started when he saw these things going together, because what they require in the PSA He said, Linda, if we hired every person living in the United States to fill out just one document, we wouldn't be able to fill out all the documents that the PSA requires.
I'm sorry. It just becomes ludicrous. It's laughable. And for owners that, if this is the first time you don't know what PSA stands for, I'm going to say it again. It's Pooling and Servicing Agreements. It is the heart and soul of securities contract law. And it's from those statements and requirements, when the bank's servicers securitize the loans, they're supposed to follow that. And of course they didn't. And that's what she's talking about. That actually the requirements were just so onerous.
I'm not talking about the work going into preparing this document. We have just the document itself, not the research, not getting the file there, not the actual transport to the custodian. All that isn't even counted in.
Oh my goodness. Well, and so this is the point. This is the point of the qualified written request. You need to find out, and you need to put the pressure on the servicer to say who is the current holder. And of course, try to get back the securitization, that mortgage-backed security that loan went into. That can be a very valuable information for the owner. Isn't that right, Linda?
Right, and it's really relatively easy for them to get. I discussed this with you earlier. I don't want to reveal it yet because I want to get all the documents. I have discovered a company in Minnesota that shows the documents they provide for the servicer on each and every loan, and it's far out past its MERS as to the information. And now once I pull down those documents and show what the servicer has, I want to give it to you to post, so that when they say they don't have this information, we're going to have in hand proof.
Right, exactly. We'll be able to prove them a liar. And frankly, my opinion, and I know that this is the opinion of 300 million people in the country, and that is, once a liar, always a liar. But trying to get them to prove things and to prove that in a court of law can be pretty difficult.
Right.
Okay, so I'm on number 11. I want to read it, and then I want to ask you what one word means. Number 11 states, competent evidence of my legal obligation to pay this debt, and that you, this is the letter sent to the servicer, are the party to pay. So tell me, Linda, what is competent evidence?
You have to have something from them in writing showing that they are the creditor, the beneficiary. And that way, it's like someone just mentioned to me, when you buy something, you get a receipt with the name of the place you purchased it, the items, and the amount you paid. That's what we want to see.
And
they're just stamping endorsements on the note.
And so competent evidence would be of the legal obligation to pay the debt to the creditor, the beneficiary of the note.
It's simply put, a correct chain of title.
And
a fake one.
And then other evidence, competent, which would be where that the servicer is the party that the owner is supposed to pay.
Well, the servicer is actually receiving it for the benefit of the trust.
But there should be some contract for that, right?
Pardon?
Shouldn't they have some kind of proof that they're the correct servicer to pay?
Yeah, they should. They have a servicing agreement that's also posted with the PSA that shows their position and what their obligations are.
So to answer this question back to the owner, the servicer should just be able to show those assignments that were done in 2006, 7, 8, whenever the loan was done, already.
But they're not going to show the servicer as the owner.
Correct, because the servicer is going to be the party to pay.
Right, and never, even though there is servicing assignments, that's a whole different world. The assignments should never show the name of the servicer, because this assignment that we're talking about that gets filed in land records has to do with the sale and the transference of the property from one entity to another.
Right, and
we'll not the bookkeeping rights.
Correct, and we'll go into that more in the recorded documents. Anyone that really understands the recorded documents will understand this discussion a little better, but don't fret about it right now. We're really trying to focus on this simple first step that many owners are going to go, well, I can send a letter, and this is the qualified written request to the servicer. And some of these items do get fairly complicated. You don't have to understand them right now. You can understand them later or ask questions of people that do understand. What you need to do is to get this letter out to the servicers and start that ball rolling. So let's quickly get down 13 and 14. They're talking about 12 and 13. The date the company began servicing, the name of the previous servicer of the loan. 14, please provide a copy of all trust agreements pertaining to this account. So would that be the pooling and servicing agreement? What is that trust agreement, Linda?
The trust agreement is in connection with the pooling and servicing, but it's not the actual trust agreement. That's it could be a New York trust, a Delaware trust, or even if they're privatized, it could be other entities. But a copy of the trust agreement would identify who are the parties and their true, what they have to do, who's the trustee, what the servicer has to do. It's one of the many documents that they file on the SEC.
All right, so this is an SEC type of document. Have you ever seen anyone get that back from a servicer?
No, they told them it's available at sec.gov.
Do they give them the link to it, or just say, you go look it up yourself?
With the link, sec.gov, but if their trust has not been named or they don't identify which pool particular loan is, that was nothing, you know.
Right. Anybody can go to the SEC's website. Okay, now you suggested, and I've entered, please identify the beneficiary and or creditor and or investor pertaining to this account. Why did you have us put that in there?
Because in California, I've noticed they'll say we're the agent for the beneficiary, or we're the creditor, or we're the investor. Now, the first two terms, they're misusing them, and I want them to say in writing they are or are not, because we can prove what the truth is.
Right.
On the term investor, MERS says on their website says for our purposes, investor means a controlling party, and so sometimes they put down the master servicer as the investor, but it's not the true meaning of the word. Somebody who has a vested interest, the people who have invested or paid for this pool, this mortgage pool.
Right.
They're important to me. I mean, they're important to help in the fight.
Exactly, and
in catching them in their lives.
Absolutely, and in understanding how they've changed the definition of the words. That has become very, very clear to me. And the whole scheme is based on a word game. They've changed definitions of words. So when they say something, just like Linda said, they'll say the investor. And as a broker, and I'm doing short sales or working, having to try to deal with banksters, and they'll say the investor. We have to invest the investor, this or that. And I just start, these days, I don't even want to talk to them because it just angers me, because I know for absolutely sure that the investor is not Bank of America. They do not own that loan. They are, like Linda said, a master servicer masquerading as calling themselves an investor, and that they never do go actually to the actual investor and talk to them about anything, because the investor would want the loan modified. Because the investor who has money in the game quickly understands it's better to get as much as I can right now than to not get payments and let it fall into foreclosure, 2 years from now, when I get even maybe half of what I could get right now in a loan mod. So this is a good step in playing back that word game. Now the next item.
Any other terms that they use in any of your documents, feel free to, amend and add them onto it.
Right. So if there's that's a very good point. Thanks, Linda. On number 15, when you look at the workshop on analyzing your recorded documents, if they've come up with other names, like here's one. What about attorney in fact? That I see that coming up a lot.
Well, you have to read the whole document to say that they'll say that the agent or the below spine person is acting as agent for the beneficiary, and then of course they always identify them on the California Declaration for Debt as the creditor. They're definitely not the creditor. Right.
Oh, that's such a good point. Number 16. Please, now the owner, we're back to the letter. The owner is asking the servicer to provide a copy of all servicing agreements. So that would be the master servicing, sub-servicing, contingency, specialty, and backup. Are there any other servicing agreements we should add to that, Linda, that you can think of?
I can't think of right now, but again, if anyone, please make us all aware of it to increase all of our knowledge.
Absolutely. And we'll quickly update the website so that everyone has the latest and greatest version. 17, please provide the QSIP number and all reference numbers associated with the above loan and associated with the creation of any and all securities transactions and sales of this loan. What do you have to say about that, Linda?
Well, that's getting them to admit that it's on the Securities and Exchange Commission, and they do use the QSIP, especially the GSEs, use the QSIP numbers for identification within the pool. Sometimes it's hard to get, but we've been flipping by little things they put here and there on your documents will help us to find out their GSE and then come up with the QSIP number. And it's true that Bloomberg was instrumental in finding out your loan and the QSIP numbers with the tranches. And now that the usage has been cut, it's still not impossible. We've got people like Neil Garfield and Joe who have other methods of identifying where your loan was sold.
And where would a person use the QSIP number? Would that have to be in a lawsuit, or is there any other way they could use that information?
Well, when I find it proves that it's been securitized, for one thing.
Right.
And it proves what tranche it has gone into, and if it's been a tranche that's no longer paying out to investors, it identifies for us when it was actually sold. Again, going back to the assignments, it helps to prove the assignments that are bogus.
Right. And then
another identifying factor for the securitization.
And truly, just like Linda said, every little bit helps. And we may not even know yet how well it helps down the road as more foreclosure defenses and effort is made to stop this fraudulent taking of the homes. And then on number 18, I quoted part of the Federal Debt Collection Practices Act, pointing out that when the owner requests the name and address of the original creditor, that the debt collector shall cease collection of the debt or any disputed portion thereof, just to remind them of what the law actually states. Are there any other things that you think we should...
This is going to be an important point in states like Florida and New York, New Jersey, where they're mortgage and we get judicial states.
Right.
Because you'll find that they file that letter, the notice of debt collection, with the foreclosure process, and they're supposed to give you 30 days to respond before they proceed.
Are they doing that, or are they just running roughshod over those laws too?
Oh, they're running ramshot over everybody.
Right. Of course they are. And they are just going to do this nationwide and take the houses. We just have to rise up and stop them.
Correct.
So let's wrap this up with a quick overview of the Dodd-Frank Act. I've put the new dates in the bank. The servicer has to respond within 5 days, and then that they acknowledge receipt of the letter, and then in 30 days they have to answer the questions. And for failing to respond, there's now a penalty of actual damages plus $2,000.
Correct. The way to collect it is that you have to file a lawsuit in federal court.
Right.
And I was appointed with a group who was doing that in California and Vegas, and they said that they were able to obtain up to like $14,000, which would also include their court filing fees would come back to them.
Now, it must be that they have an attorney that knows how to do that?
Yes, that's what they specialize in.
Right, because I got a letter from one of our contacts in North Carolina who said, please let me know how the QWR lawsuits are going. We filed one. The person has a perfect mortgage history. The defendants didn't answer, so he filed, and then she says, for the $200 and $36 court costs. So evidently the former damages were just $200. I'm not sure. And the judge just dismissed the case, saying there were no damages. So she's saying that in her experience, the judges don't get it. So she called Elizabeth Warren and the Consumer Financial Protection Bureau and the U.S. court, but she couldn't bring a $2,000 lawsuit into the federal court, and not one person knows what she's talking about. She also called Barney Frank while he was still in office and never got an answer. So
no, there is a firm. Let me get in fact, I'm traveling back to Florida now from my personal business here.
Okay.
When I get back into my office, I'll get that contact information and send it to you, because I'm sure they'd help people nationwide.
Right, because this is what I would call
money for people. They have been getting money. They said it's relatively easy.
I would call this a boilerplate lawsuit. It's based on federal law. It's the same everywhere.
Right.
It's the statutes are clear and plain. So
once you've notified them that you're contesting it,
right,
keep a record of every time they call you.
Right. Right.
It's $1,000 a phone call.
I will put that in my, I will update the verbiage on my website. That's fabulous to know. And then the one last thing before we close up today on the Qualified Written Request Workshop, down at the last paragraph, it says, just to be sure I've contacted the correct party with this letter, notice to agent is notice to principal, and notice to principal is notice to agent. Why is that important to say?
Excuse me, would you read that again? I don't have the document in front of me.
Oh, sure. I just said notice to agent is notice to principal, and notice to principal is notice to agent.
Well, that notifying one is in case there's none that you've been able to identify. If the principal is saying, well, you had to contact my agent, and the agent is saying, no, you had to contact the principal, they can't shift blame. You're
right.
Exonerating yourself from that blame shift.
Yeah, from pointing and, oh, not me, not me, not me. I just see the little kids running around the yard going, not me, I didn't do it.
Got them both by the collar, and they're both accountable.
And now at the bottom of the letter, just as a final statement, we've copied the loan servicer, the foreclosure trustee, the executives of the mega bank. I'm going to make edits to this based on this workshop so that it will say the things that Linda advised us to have, where to copy, because we want to let everybody know involved in your situation with the recorded documents on your property, what you're doing, so that you've given notice to everyone. Anything else you want to share with us, Linda, as we close this up? Anything else? Any other advice?
No, except we'll follow through on how the procedures are to collect on these. And, anyone who's got suggestions, we're open, or knows anything that we are not aware of, we want to know.
Absolutely, absolutely. Together, united, we can stand and fight back and get some restitution. Divided like we are right now, they're just chewing us all up one by one, spitting us out. Thank you. This is C.J. Holmes, founder of Homeowners for Justice, with a workshop, Qualified Written Request. Get yours sent out today.